brought the focus a little bit as to, what courts do and how they kind of get involved in the elections, if they do. Sometimes they don't get involved. So the focus of this program is really to kind of talk about the different cases in which Supreme Courts have issued decisions on voting, and kind of talk about a little bit about the 2020 election, what happened with that, where it's going, because some of those cases haven't really been decided yet. And the focus of this one, in terms of the cases that have been decided, we're going to be talking about Bush v. Gore, which was from 2000, Citizens United versus Federal Election Commission, or the FEC, which was from 2010, and Shelby County, Alabama versus Holder from 2013. These cases that I just mentioned they're pretty still widely discussed, and they also kind of offer different impacts that have resulted from those decisions. So this program is going to take a little closer look at those cases, again, kind of discuss the facts, the holdings, the rationales of those cases, and the impacts that might still be affecting today's political climate. So as I mentioned, before we start looking back into the past, let's take a little look at the future and revisit the 2020 elections to kind of understand where we are right now. So I'm sure many of us would like to forget 2020 for one reason or another. But just like the year 2020, the 2020 election had its own set of unique difficulties. With the pandemic going on, there were a lot of things that were impacted, and this included the primary and the general elections. There was an ongoing question that the states had to ask themselves when conducting their voting, and one of them was trying to balance a sense of safety and health concerns with the pandemic going on, while also maintaining the integrity of the vote. So states had done several different things as the elections were approaching. Some of these things included offering mail-in ballots, allowing more absentee ballots to be requested due to the pandemic, providing more locations for drop-off ballot boxes, drive-in ballot boxes in some states, extending deadlines for registrations, and even extending deadlines for receipt of the mail-in ballots. So because these measures were kind of being taken, and some of them were kind of being taken very rapidly, the lawsuits really started to pop up as the changes were starting to come up. So this is just a brief overview of some of the cases that kind of popped up during the elections. You'll notice that a lot of these lawsuits took place in a lot of swing states. We have Pennsylvania, some in Wisconsin, Texas, Alabama. And these lawsuits were all they were focusing on different things, mainly about the changes that were being enacted. And what was coming up currently with these cases were that parties were seeking preliminary injunctions to stop something from happening, whether it was to stop accepting mail-in ballots after a certain deadline or restrict the number of drop-off poll locations. Now, some of you might have heard of the term preliminary injunction, but I'll just briefly explain that. So a preliminary injunction is a legal tool which seeks to maintain the status quo. It's a way of kind of preventing somebody from acting in a certain way. It's a pretty hard remedy to ask the court to do because it's usually decided before a case is actually decided the full issue on the merits. So you're kind of asking for a judgment of sorts before the case is actually decided. And you're also asking the court to stop somebody from doing something which might be in their right to do because, again, the case hasn't really been decided. So to ask the court to issue a preliminary injunction, it's a hard remedy. Courts don't usually like to issue it. And in order for it to actually be issued, you have to demonstrate a few different things. One of those things is that you have to show that you're likely going to win your overall case, that there's a likelihood that you're going to win on the merits when your case actually goes up to the court. You also have to show that without the injunction being issued, you're going to suffer some sort of harm, that the person's going to keep doing something that's of an injury to you, and that's why while the case is being decided, you've stopped it, you made a status quo, and everything is where it should be. And there's also a balancing of equity, meaning that there's a fairness element to it. The courts look at what's being requested and decide, yes, it's fair to say not to do something. So the preliminary injunctions, they're very fact-based. And so one court might grant a preliminary injunction and one court might not. In some of these cases, the preliminary injunctions were granted in the sense that the court said, yes, you can continue to accept mail-in ballots for 3 days or 7 days after. Or, yes, you can put in more drop-off boxes. You know, we understand that this is a unique circumstance with the pandemic. The reasons that those were granted was that the court realized that, you know, states are trying to navigate this unique situation. They're trying to understand that people might not be going to the polls in person to avoid, you know, lines or anything like that. And they also know that the Postal Service was experiencing a lot of delays with the influx of ballots. So they were like, oh, we understand you need more time to get the post office to deliver the stuff, the mail-in ballots to wherever they needed to go, or you need more ballot boxes to collect. So in those situations where the court had granted those changes and allowed the states or the counties to continue collecting the ballots, the courts had weighed that the impact of allowing everyone the chance to vote and the right to vote was greater than hypothetical threats of fraud. The courts have found when they were discussing fraud that there wasn't any fraudulent activity, or not to the extent that was being suggested. And so in that balancing of equities, the chance to receive the ballots and the votes was greater than a hypothetical threat that hadn't been proven. In situations where the courts didn't, or they kind of stopped ballots from being collected beyond the deadlines, or they stopped the additional ballot boxes, a lot of those reasonings were really because the court found that the states had provided other methods, other avenues that were acceptable. This could have been early voting or a designated deadline that everybody was aware of. And they thought that it was fair to not be changing the ballot, absentee ballot forms, or not to change the deadlines that everybody was aware of. In fact, they actually thought that sometimes changing the methods too frequently, or maybe even too close to the election, was actually more harmful because it was causing some voter confusions. Excuse me. So that's just a little insight into what some of these cases that were popping up while the votes were coming in for this 2020 elections. And these also span both the primaries earlier and the general election in November. So these were all taken at state levels or appellate levels in the federal courts. And the Supreme Court hasn't really weighed in on these too much at the moment. So if a case did end up going to the Supreme Court, which was pretty rare, either the Supreme Court didn't even hear them, or they've kind of like ruled on the injunction aspect of it. And again, the injunction is kind of the middle layer before the actual case is being decided. So these cases might still actually be um, being considered at later times, because again, they were kind of focusing more on the intermediate remedy for the preliminary injunctions rather than the merits of them. And again, we're kind of still waiting to see how far these lawsuits will go, if they're going to go any further, and if they do go further, how far are they going to go up the chain? Are they going to make it up to the Supreme Court? It's a little bit up in the air at the moment. But as I mentioned, as you can see from this slide, the 2020 election definitely had a lot of lawsuits coming in. It was a pretty litigious, and sometimes it felt like there was a new lawsuit that was filed a day or a week. So, with the interest in the court systems and with the lawsuits kept kind of piling in, I know for me at least, it made me wonder, like, boy, are we going to be seeing, another Bush v. Gore situation for this election? But when you kind of read into these cases that came up for the 2020 election, and you look at Bush v. Gore, they're actually quite dissimilar. And we obviously didn't have a Supreme Court ruling on any of the recounts, but when we kind of talk about Bush v. Gore, you're going to kind of see that the facts are actually quite dissimilar. So does anybody have any questions so far on any of the preliminary injunction matters or anything? So for Bush v. Gore, I'm sure a lot of you probably do remember about this election. This was the 2000 election. And going back to the facts, this has a lot of facts to it and a lot of different deadlines and timelines going on. So I'm going to try to do my best to really streamline it. But back in 2000, Florida had used ballot cards for the election. The ballot cards were meant to be punched with a stylus, and some of those ballots, whether through a mistake or just an absent vote, weren't punched in the precise manner that it would end up being registered as a vote by the machine. Sometimes there would be a little piece of the card hanging out, and this is what was known as the hanging chad, as many of you probably remember that term. And sometimes it was just like a little indentation into the card. And this picture on the slide, that was just a search for hanging chad. I don't know who this gentleman is. He's everywhere on these images, so I apologize to this gentleman, but that's what the Florida was really looking at. What they were looking at, these chads and these little dimples or hanging pieces on there. So the day after the election in 2000 was November 8th, and Florida had reported that Bush had received 2,909,135 votes, and Gore had received 2,907,351 votes. So the margin between the votes in favor for Bush and the votes in favor for Gore was 1,784, and the margin was less than 0.5%. So because it was such a narrow margin, the election law, it required an automatic machine recount be done. And after that recount was done, Bush was still shown to be ahead, but by an even less margin than before. And so that's when the manual recounts were starting to be requested. So now we go to November 26th, and Florida has certified the results and declared Bush to be the winner. And that's when Gore had filed a complaint which was contesting that certification. He was saying that because it was so tight, there could have been illegal votes that were registered, or there could have been legal votes that weren't counted, again, because of the issue with the hanging chads or the improper specificity into which these punch cards were being punched. So because it was such a narrow margin, and because there was a lot of issues with how to actually interpret these ballots, it caused doubt into the certification, which is why it ended up in front of the Supreme Court. So during, hold on one second. So the problem that was really before the Supreme Court was not so much that the recount was being requested or that it was being done, but the question that was really raised was, how is Florida actually doing their recount? As I mentioned, with the hanging chads, you're supposed to punch in a certain way, and it's going to show that it's being punched for a particular candidate. Sometimes the paper would not be completely punched through. Sometimes there would be a little indentation. And what Florida counters were doing were that they were manually recounting it, and they were deciding for themselves exactly, was this a vote for Bush? Was this a vote for Gore? And the court found, yes, they can be looking for the voter's intent. We can't ask the ballot what was meant, and so we have to try to discern what the intent was. But the problem was that there was no uniform method into which the counters were deciding what the vote was. And without that uniform method, the court had found that there wasn't really an equal application to all the votes. And without that, one county might be reviewing the ballots in one way, another person in that same county might be reviewing them in a completely different manner. And so that's really, it wasn't so much, again, the recounts. It was, well, we need a system so that every vote is being afforded the same opportunity to decide how this person has voted in this particular state. And the other thing that was also happening at this time was that this case was before the Supreme Court on December 9th, I believe, December 8th or December 9th. And without this method in place, a uniform set of rules and procedures for Florida to follow, they were approaching what's called the Safe Harbor Day. And again, this day was also kind of brought up in 2020 election. So Safe Harbor Day was on December 12th. Okay, so it was 4 days from when it was in front of the Supreme Court, and 4 days to December 12th, which was Safe Harbor Day. And Safe Harbor Day, it's a deadline for the states to certify the results of the presidential election. When a state certifies by this deadline, those results have to be counted by Congress, and it provides a safety net for the states so that once they certify their results, it's not questioned anymore, and the Congress will be accepting it at the time that they count the election in January. So with Bush v. Gore, again, they had to try to come up with a uniform system, but they also had this deadline. And there was a lot of back and forth discussions amongst the justices, but ultimately they decided we can't really have Florida come up with a uniform set of rules in time for the Safe Harbor Day. So the recount stops. And then Bush was certified as the winner, and then that's what happened with Bush v. Gore. So going back to the 2020 election, again, all those lawsuits coming in, a lot of discussions about recounts and stopping the vote. But when you actually look at the 2020 elections and the issues being raised, the difference is that with Bush v. Gore, they were talking about the method into which things were being counted, and was very fact specific for that particular state and that particular election. The 2020 election was different because they were trying to seek actual stopping votes from being accepted. Again, those are going back to those preliminary injunctions where some ballots were being accepted several days after when they normally would be accepted, or having issues where some like an absentee ballot wasn't properly witnessed and trying to resolve that. So rather than having the votes being not counted at all, like the 2020 election, Bush v. Gore was like, no, we have these votes, but how do we actually count them? So Bush v. Gore it's a very important case, and it was certainly an important case in 2000, but it's so fact specific that it's actually very hard to really have a lot of implications into future elections, because again, it's such a narrow issue that the court was looking at that time. So while it's been quoted, Bush v. Gore has been quoted in several lawsuits, it's actually kind of rare to really see how it will be impacting future elections without having a similar pattern emerge. But one thing that Bush v. Gore and the 2020 election did have in common with each other was that it was kind of about the court's role in interpreting voting counts, and whether it was the method or rather was actually just accepting votes. That was kind of the similarities, if you will. But again, they're dissimilar enough that they're probably not, Bush v. Gore isn't really going to be affecting the 2020 election, and it might not even be affecting future elections if we're not dealing with the same uniform method of counting that caused the issue. But another way, and I apologize, I know Bush v. Gore has a lot of facts to it, so I hope that at least kind of provided some guidance for you in better understanding that one. But courts have made other decisions that have affected the election, and one of those ways is through campaign contributions. So this is the case of Citizens United versus the Federal Election Commission, or the FEC. So today, hundreds of millions of dollars are used by what's called super PACs. PAC is an acronym for Political Action Committee. And with super PACs, a majority of the funding for elections really comes from a handful of individuals. There was a 2014 report by the Brennan Center for Justice that reported that of the $1 billion spent in federal elections since 2010, nearly 60% just came from 195 individuals. And between 2010 and 2018, super PACs have spent approximately $2.9 billion on these elections. So what the case of Citizens United really did was that it gave corporations and unions a green light to spend unlimited amount of sums on ads and other tools that help influence the election. The facts for Citizens United was that Citizens United was a not-for-profit organization, and it had received about $12 million or so just from donations by individuals and other corporations. And Citizens United had released a film in January 2008, which was called Hillary, the movie. And it was a 90-minute film that was on Hillary Clinton during the 2008 Democratic primary elections. And it had been released in theaters and on DVDs. And Citizens United had also wanted it to be distributed through video on demand formats as it got closer to the election. So they had created a few little different ads, a few 10-second ads and a 30-second ad that would be advertised on television. So at the time, there was a federal law called the Bipartisan Campaign Reform Act of 2002. And what that law did was that it prohibited corporations and unions from using their own general funds to make direct contributions to candidates, either in favor of candidates or against candidates. And while the corporations were barred from using their funds, they could create separate segregated funds, which is what the PACs are used for, the Political Action Committee PACs. So the corporations, not only could they not directly fund, but there was another section of that law that said that you couldn't do what's called electioneering communication, which means you couldn't do broadcasts or advertisements for political campaigns within 30 days of a primary or 60 days of the general election. And this is what prompted the issues by that brought this lawsuit from Citizens United to put the Hillary movie on the video on demand format. Citizens United were going to run the ads 30 days before the primary election. And so they sought this lawsuit in front of the Supreme Court to make sure that they weren't going to be facing any civil penalties or criminal penalties by violating this Bipartisan Campaign Reform Act of 2002. And what the court ultimately decided in Citizens United is that the public usually begins to concentrate on the elections in the weeks leading up to the election. So it would make sense that corporations would want to be advertising. And corporations, are allowed to communicate. They are a legal entity in front of the courts. And so by telling a corporation that they can't advertise within a 30 or 60-day time period, it was essentially saying that they were prohibited from speaking, and it was a chill upon speech and a form of censorship. The court's rationale was a bit of like a money talks kind of reasoning, where this is how corporation speaks, by providing money or providing advertisements. So I just provided this quote, which is saying, political speech does not lose First Amendment protection simply because the source is a corporation. And because corporations speak through money, we can't say that they can't advertise in a certain manner. The results of Citizens United was that it overturned a 1990 case called Austin v. Michigan Chambers of Commerce, which is the law that really set forth that restrictions of that corporations can't use their own funds, their own general funds, for a particular candidate. And it also overturned, or partially overturned, the McConnell versus Federal Election Commission, because not only could you not have the corporations directly do it, contribute to a campaign, but you also couldn't, the McConnell case said you couldn't do it within that 30-day period. The court found that was too onerous of a restriction and overturned that. So what Citizens United did was the first step, in that they said that a corporation could fund a political candidate either in support or against, and there was no 30-day or 60-day limitation as to how far they could go. But Citizens United went even further, in the sense that later that year, in 2010, there was another case called SpeechNow.org. And what SpeechNow did was that it used the Citizens United case as a precedent, saying that, well, you just told us that corporations have the right of free speech and we speak through money. So now what SpeechNow is saying is that, well, you can't tell us that corporations have any sort of limitations. PACs were limited to about $5,000 per year. And to say that we're limited to that is another way of saying that our speech is being chilled. So with the combination of Citizens United and the combination of Speech Now, there is basically no limits to what corporations can provide to these elections. It created the super PACs, which can just provide as much money as they can towards these elections. And there's also issues that some of these super PACs, because they're not really corporations and they're not really not for profit, they don't have to disclose exactly where their money is really coming from. And the concern that stems from both Citizens United and Speech Now is that it's allowing an unregulated and unchecked system for corporate spending to really amplify elections and to possibly really, it tips the scales towards the wealthier companies that can provide as much money as they want, and it kind of drowns out the lesser funded corporations and impacting how they can be forceful in making their political speech. Citizens United is probably one of the more controversial decisions that is still around. And again, it's just the impact of it is just that it's just putting a lot of corporate money really behind these elections. And without a spending limit in place, it's an ongoing issue and an ongoing concern for a lot of people as to who's controlling the election and you know how much is it really just corporations deciding who gets airtimes and who doesn't get airtime. There is some discussion, and there have been past legislations that have been trying to reinstate those limits. I think there was one bipartisan bill that was in its very early stages currently, but until that's passed, it's still an unlimited spending cap for these corporations, and the problems that are feared from the Citizens United and Speech Now are still a problem today. So now we've seen that courts have issued decisions that are based on counting votes, and also about how the courts have impacted how elections are funded and contributed. So another way that the courts have been involved in election is through another piece of legislation called the Voting Rights Act of 1965. And the decision from Shelby County, Alabama versus Holder, it's sometimes actually referred to as the gutting of the Voting Rights Act of 1965. So the Voting Rights Act was signed into law by Lyndon B. Johnson, and it was in response to how some states were discriminating voting rights for minorities that were in place since the Reconstruction era after the Civil War. Some of these states were still using tactics like literacy tests and making voters have to recite the Constitution before they were allowed to vote. And so the Voting Rights Act of 1965 was really meant to enforce the spirit and the equality of the 15th Amendment. So under Section 5 of the Voting Rights Act, certain states had a history of discrimination practices, or I'm sorry, certain states who had a history of discrimination practices, they had to obtain federal permission from the state before any of their changes to voting laws were put into effect. So if a state that was listed as a covered jurisdiction under the Voting Rights Act wanted to make a change to their voting laws before that was enacted, they had to kind of have it reviewed by the federal government or by the state government and make sure that it wasn't being used for discriminatory purposes, or that it wouldn't have a discriminatory adverse impact to it. So when the Voting Rights Act was enacted in 1965, it covered the states of Alabama, Georgia, Louisiana, Mississippi, South Carolina, and Virginia. And again, these were states that at the time had shown that they had discriminatory practices in their voting. And so by enacting the Voting Rights Act and having any changes being kind of checked out before it was implemented, it was a way to kind of stop any further voting policies from being enacted before it was actually enacted and harm the voters. So it was kind of like a gatekeeping method to make sure, okay, I see that you're changing this law. It's not going to hurt the voting. You can continue. Or this is a problem. It's going to have discriminatory results. This isn't allowed to happen. You have to continue voting how you are voting. So the Voting Rights Act was initially meant to expire in 5 years from when it was enacted. So it was supposed to end in 1970. And the Congress, when it was coming up for expiration, Congress had renewed it for another 5 years. And it also, when it renewed it in 1970, it actually extended some more jurisdictions that they found were also having discriminatory practices, using voting tests or had a very low voter registration system. And actually in 1970, when they extended the jurisdictions, this included areas of California, New Hampshire, and even New York. Then in 1975, when it was meant to expire again, it was renewed by Congress for another 7 years. And in 1982, it was extended again for 25 years. And in 2006, it was reauthorized for another 25 years. So this kind of brings us to the area of Shelby County in 2010. So in 2010, Shelby County, Alabama had filed a suit to try to overturn sections 4B of the Voting Rights Act, which is what listed those particular states. And it also wanted to overturn section 5, which is that little checkpoint for the states that if you were covered under section 4B, if you wanted to enact this change, it had to be reviewed by the federal government before that could be enacted. So at the time that Shelby came in 2010, there were 9 states that were covered by the jurisdictions, and that's the little map that you see on my slide. These included Alabama, Mississippi, Louisiana, Texas, Alaska, Georgia, South Carolina, Arizona, and Virginia. And there were some other states that were partially covered, which included Florida, New York, and California. So up before the Supreme Court, the court agreed with Shelby County and found that Section 5 of the Voting Rights Act was facially unconstitutional because it focused on just a select few states. The court reasoned that states should have equal sovereignty in voting, and because you were targeting certain states, that was unconstitutional. They also stated that Section 2 of the Voting Rights Act did prohibit all states from any sort of discriminatory practices. It just, Section 5 focused on those select few that had had a history, and that before they invoked any changes, they had to go through that checkpoint. The court in Shelby had noted that there had been a lot of improvements that had been done for voting, and that these improvements were really coming from the Voting Rights Act. And although there was a need for Section 5 when it was first enacted, to continually extend it without really changing the system as to, what's a covered jurisdiction, what's not, it was just, that was what the court had considered to be unconstitutional. The court also pointed out that relying on past data wasn't relevant, and they found that in a lot of the covered states for the Voting Rights Act, the registered voting amongst the minority population had improved, and they also noted that some elected officials in those areas were part of that protected group that Section 5 was meant to protect. So for those reasons, that's why the court in 2010 said that Section 5 was unconstitutional, and therefore they removed those protections and that gatekeeping checkpoint for those listed jurisdictions. Now, what a lot of people are concerned about as a result of Shelby was that before Shelby, if those states were covered by the Voting Rights Act, the government had the obligation to show that those changes weren't discriminatory. And it kind of goes to that open and transparency. If you were a covered jurisdiction before you had to enact a change, you had to show that it wasn't discriminatory. And so there was just a lot more openness. And it's like the saying goes, sunshine is the best disinfectant. They probably knew that people would be looking at these, and therefore they made their changes so that they didn't have any sort of discriminatory purpose. And what people fear is that without this little checkpoint, that if there are changes to the law, there's question is, well, is this just a change to the law, or is there an underlying purpose? Without that little extra checkpoint, we don't know. And also, the government, if you were under Section 5, had to be the one to show that there was no issues, that there was no nefarious purpose. And without that now the burden shifts to the voters. And if they feel that these voting changes are discriminatory, it's up to the voters to show how it's discriminatory. So again, it just shifts that burden from the government showing it's not to the voter showing it is. And it just kind of, again, just raises a lot of questions, if there's a discriminatory purpose of it, and there's just no safeguard anymore for it. After Shelby was decided, states started making more changes to the zoning law. Some of these changes have included voter ID laws in certain states, closing certain polling locations. I think even in the primaries, there was a lot of news articles related to how the primaries in Georgia had a lot of closings and closures of polling places. And a lot of people wonder if that was, remnants of Shelby, that these changes were made. They weren't checked to see if there was any sort of discriminatory purpose or results. And you saw all those pictures with people waiting in long, long lines for Georgia too. And other sort of, proof of citizenship. These are just some of the changes that have been created by certain states after Shelby was decided. So Shelby, as I mentioned, with the Georgia primaries, it's a continuing topic of discussion as more and more voting changes are being made. Many states are adding bills to make changes to the voting laws. And currently, a lot of those changes are targeting the access to absentee ballots or putting more restrictions on mail-in ballots than were previously allowed for the 2020 elections. And again, we're seeing a lot more. In fact, this is from the Brennan Center of Justice. Again, this is a updated map showing all the number of voting registrations that have come up since the 2020 elections. Just about pretty much every state has at least one, and some, again, the swing states, Georgia, Texas, Arizona, have quite a bit.
One question, Kim.
Sure.
Is that why the new Georgia laws?
Can you repeat that? I didn't hear that.
Oh, sure. They're asking, is that why there's a new Georgia laws right now?
Yes, it's very well. There probably because Georgia was so heated during the 2020 elections, and then you had the runoff with the Senate. I think that a lot of these laws are reflecting on the changes that were allowed, increasing absentee ballot, increasing voter registration deadlines, extending the mail-in ballots. I think that has prompted a lot of these legislations that have come forward. And again, under Shelby, there's no checkpoint to make sure that there's not a discriminatory purpose or discriminatory results even. So these legislations are moving forward, and I believe, I haven't checked recently, so I do apologize for not being up to date, but I believe that there have been a few lawsuits that have been filed to challenge the Georgia law, but I haven't heard anything about it. But yes, I would say that Shelby impacts the Georgia laws because there's that lack of checkpoint to make sure as to the purpose or the intended results of it. Did that answer the question for the person?
Yeah, thank you.
Okay, great, thank you. So we're kind of ending towards the end of our presentation here. But again, just the 2020 election really raised the profile of voting rights. And again, even from this slide, you can see that just a lot of states are really making a lot of changes in response to, extensions of absentee ballots, allowing, more polling locations, or allowing more drive-through options. So the lawsuits that stemmed from 2020, again, they haven't really been fully decided yet. So their impacts are still being weighed, but as you can see, there certainly are moving pieces to seeing what the impacts of the 2020 elections may be.
I have a question.
Sure.
All right. With the fact that the Supreme Court traditionally right now has 9 members, but it didn't always have 9 members. The numbers went up and down from day one. What are the chances of adding more justices to sort of even out the Supreme Court? Are there senators that would vote for something like this, or is this a dead issue?
It's certainly not a dead issue. So basically, in the history of the Supreme Court, there haven't always been 9 justices, as you mentioned, and there's no constitutional requirement that there have to be 9 justices. So there have been a lot of discussions with this current administration and with previous administrations, of adding more seats or taking seats away. I believe I had just read, and I didn't look too far into it, but I believe that the Biden administration has actually opened this discussion up again as to possible changes, either adding court justices or putting term limits on justices. Again, I haven't read fully what is being proposed. I think it's actually more of a report to kind of see possible options, but
Biden has proposed a commission to set up.
Yes. Oh, yeah.
Yeah, something like 35 members on it. It's a big organization.
Yeah, I had read a little bit about it, but like I said, it's a commission, and to kind of study some of those possibilities. So the issue as to whether could be more seats is certainly an open issue. It's one that comes up from time to time, and it's one that is potentially being explored now. But that kind of brings me to my conclusion, in the sense that, with the Supreme Court, we've seen court cases where the impact is immediately felt, but maybe not felt for future elections, like Bush v. Gore, again, very fact specific. And then we've seen court cases like Citizens United and Shelby that can really have a lot of widespread impacts that last decades or generations even. So while we can't vote for the Supreme Court justices directly, we can vote for senators, congressmen, and if I don't know exactly what would be happening with this latest study going on with the Biden administration, but your vote still counts. Even if you can't vote for the actual justices, you can vote for your representatives who do have a say in that. So I hope you found this information helpful. I know sometimes the law can be a little bit of a dry subject, but it can be interesting too. And it is important to keep following the implications of the 2020 elections, of these voter changing laws that are coming up, just to kind of keep an eye out for it. And we'll have to see how the Supreme Court, if the Supreme Court handles it, and how they handle it.
Thanks, Kim. Really appreciate it.
Thanks very much, Kim. Very useful, very entertaining.
Thank you. Good, I'm glad.
All right, thanks for coming, everybody. Have a good night, or I guess
And
afternoon.
enjoy the rest of
nice
this
weather.
gorgeous day outside too.
For sure.
Nighttime here.
Oh, okay. Well, enjoy the night then.
Will do.
Okay.
Cheers.
Thank
Thanks
you.
again.
Thank you.
Bye.